From Eyewitness News, this is breaking news.
Good afternoon. Right now, former Patriot Aaron Hernandez is facing a judge. Now, this comes just hours after his arrest in connection with the local homicide investigation. We are taking you live inside Attleboro District Court, where you see Hernandez right now. The former New England Patriot is about to be arraigned any moment. Let's listen in.
Possession of a large capacity firearm. Count 5, possession of a firearm without an FID card. And count 6, possession of a firearm without an FID card. Date of offense on the last 4 complaints, June 22nd, 2013. Record plea will be entered on behalf of the defendant.
Okay, we do have appearances filed by counsel, and I believe we'll send in documents for the counsel. Good afternoon. Can you introduce yourself to the record, please?
Good afternoon, Your Honor. Michael Fee for Mr. Hernandez.
Good afternoon. Counsel.
James Sultan for Mr. Hernandez.
And Charles Rankin for Mr. Hernandez.
Okay, good afternoon, folks. And so Mr. Hernandez says to remain on charges. Commonwealth, is there any request? Good afternoon.
Yes, Your Honor. District Attorney Stan Sutter for the Commonwealth, assisted by First Assistant Bill McCauley. Mr. McCauley will speak for the DA's office.
Okay, thank you, gentlemen. Are we ready to proceed? There was a request for bail in this case?
We do request bail, Your Honor.
Okay, all right. Commonwealth, may proceed.
Thank you, Your Honor. Your Honor, the defendant is charged with the murder of the Oakland boy, a 27-year-old man who lived at 10 Basin Street in Boston. He lived at that home with his family, and he was last seen leaving the company of the defendant on June 17, 2013, at approximately 2:30 in the morning. His body was discovered at 5:30 p.m. by a jogger running in an area, a secluded area in an industrial park in North Attleboro. That area was essentially a storage area for gravel and sand, and it was approximately 1/2 mile from the defendant's home. The jogger quickly notified people who worked in businesses nearby, and as a result, 911 was called. The police responded. Upon responding, it was evident fairly quickly that they would be investigating homicide. They observed numerous gunshot wounds to the body. Mr. Lloyd was found in a condition on his back. Gunshot wounds had struck his arm, going through his outer forearm and exiting the inner forearm. Also striking him in the side of the right flank. Shot to the back and 2 to the chest. After the scene, secured crime scene services unit as part of the Massachusetts City Police processed the scene, and they recovered at that time 5 .45 caliber spent shells from what appeared to be a semi-automatic weapon, based on the location and the distance between. At that time, the victim, Mr. Lloyd, didn't appear to have been robbed. There was no evidence of a robbery. In fact, property was found on him, beginning with a wallet, his phone, and keys in one of his pockets. The police were quickly able to determine his identification based on the license that was found in the wallet, and as well as the keys. When the keys were taken out of his front hand pocket, they had it as a rental car, and it actually had a registration that they were able to run. That registration came back to require that it be rented by the defendant. The phone that was recovered was also analyzed and revealed that there had been communications between the defendant and the victim within hours before the victim's death. As a result of learning the identification of the victim, the police went to his home where they were met with by family members. They were informed of the news, but also they assisted in making a positive identification of Mr. Lloyd. One of the family members, his sister, was spoken to, and she indicated that at 2:30 a.m. earlier that morning, so approximately 14 hours earlier, she had been out the front of her house, and her brother had left, getting into a silver Nissan Altima. The investigations revealed the defendant had been renting a silver Nissan Altima. At the time she last saw him getting into the vehicle, there were 3 people in the car, and she had been aware of a relationship that her brother had with the defendant that had begun about a year prior, as the sister is the girlfriend or the fiancée of the defendant. So they would see each other occasionally at outings, family outings, at the home of the defendant in North Alabama. But recently, they started to get together outside of the sisters. As a result of learning information about that, they went to the defendant's home. When they went to his home in North Alabama, they knocked on his door. There was no answer to the door. They banged a little bit more, and they could see that people were home. There could be lights on, TV on, before they came to the door. After some period of time, they went next door to the neighbor, spoke to the neighbor, who indicated he hadn't seen the defendant. Shortly thereafter, they had gone and sat in the cruisers. The defendant came out of his house and indicated to them that he had seen the police out in front because he had been watching them on his surveillance, that he had surveillance. Subsequent search warrant was issued out of this court, permitting the state police and North Alabama police to seize surveillance footage. The defendant had recently installed extensive surveillance footage throughout his home, inside and outside. In fact, there were approximately 14 cameras. After executing the search warrant and reviewing the footage, they noted that shortly after the victim's death, footage was missing in the hours, approximately 6 or 8 hours after the murder. They then examined the phone, the victim's phone. In the phone, they found text messages that had begun on Sunday night. This is belonging to Mr. Boyd. And at approximately 9:02, the defendant had sent a text message to a friend of his who was out of state. He indicated at 9:02, please make it back. 3 minutes later, the defendant had texted a friend of his who lived out of state and said, please make it back. 3 minutes later, he texted the victim, indicating he wanted to come by and get together with him. 9:35, he texted again his friend from Connecticut, indicating, get your ass up here. About an hour later, 10:23, another text, hurry your ass up. These two individuals arrived sometime later in that evening. And again, at this time, the surveillance footage that captured the outside of his home and showed the arrival of them in a vehicle. At that time, the defendant meets with them, and there's some arrangement or adjustments being made to the car. But at some time after that, they go inside, and at that time, the defendant is observed with a firearm. And that he indicates to a person inside, makes a statement, he's upset that he can't trust anyone anymore. At that time, the three of them departed the defendant's home at 1:12 in the morning in the silver Nissan Altima. This was captured on surveillance, but was also corroborated by other phone records and cell tower information. They began the course from the defendant's home at that time, out to Route 95, and actually going south towards Rhode Island. Shortly thereafter, they turned around and headed north. The cell tower tracked their movements all the way to a stop at a gas station, which is right off of Route 128. 2:10 in the morning, they stopped. The defendant bought gas, bought two other items, Bubblicious blue cotton candy gum and Black & Miles, which are rolling papers for marijuana. They then continued their journey to the home of the victim. 2:32 in the morning, they arrived outside the victim's home and they sent a text message through here. The victim was then observed by his sister leaving the home, entering into the car that the defendant was driving. From there, they proceeded down the street on Facein Street. And there's the neighborhood surveillance camera that also captures the defendant arriving in the car. He appears to be consistent with the silver Nissan Altima. It also depicts the defendant wearing clothing that he had been earlier seen back at his home. At that time, there's additional surveillance camera that tracks his movements through the city of Boston. He goes to Blue Hill Avenues, to Dennis Street, to Dudley Street, to Hamden Street, before he arrives at a location on Molina Cass Boulevard, at which time it's presumed that he got up on the highway. That's presumed based on time, distance, and travel that it would take for him to leave that location and then later arrive back in the Calico, which is captured on video. During the ride, as they began to ride the journey back to North Attleboro, there's a conversation that he has with the victim. He's upset, and he indicates the two of them had gone to a club on Friday night, and they're spending the whole night together. And there was certain things that had happened during the night that he was upset about, and now didn't trust the victim. He told him one of the things was he was mad that he had talked to some people at a club. They had come to a club, Rumor, in the city of Austin. And at that club, the victim had spoken to a couple of people, and the defendant told him that he was upset about that because he had essentially troubles with those people. As the car continued now on Route 95, let's write that, 128 to 95, the defendant at 3:07 sent a text to his mother, further corroborating the temperature in the car. He sends a text that said, "Did you see who I am with?" He got no response, and again he texted at 3:11, "Hello?" This time they're now on Route 95, consistent with the time and the distance of travel. The sister whose phone had died had now plugged it in, and at 3:19 responds, "My phone was dead. Who?" 3:22, the victim responded, "NFL." 3:23, he then sent the last text he would ever send, "Just so you know." Now, as I indicated, Your Honor, they had gone down Route 95, and at exit 5, they got off on Route 152. As they travel to get to the defendant's house on 152, they go by a Gulf station. That has surveillance footage, which notes the time of the arrival of the Nissan Altima at 3:20 in the morning. 3:22, this is now the entrance to the industrial park. 3:22, they go by a Seacom Supply. That is the time of the first text when he's indicating NFL. When the sister asked who, because he sent that out about who he was with. 3:23, he passed a business, an industrial business called Metalor Inc. Now at that time there's a fork in the road. To get to the defendant's house, you would take that right and continue along John D. Boulevard to get to his home. Surveillance footage picks up his vehicle going straight down the road that leads us to this gravel road that takes us down behind industrial buildings. It's a secluded area, there are no homes there, there are no artificial lighting. It goes onto a gravel road. In fact, you can see the car when it hits the gravel, puts on its brakes. The car goes down there, 3:23. 4 minutes later, the car is visible again. During the interim, between 3:23 and 3:27, people who are working the overnight shift hear gunshots. They indicate there's a multitude of gunshots. One woman indicates there's approximately 5. 3:27, after he comes out by Metalor, he proceeds by another business, 3:28, where his car is picked up in Nissan Altima at Bell's Power. 3:28, North Attleboro Electric Department. And 3:29, his own video picks him up coming up his driveway into his home. The distance from the location of where Mr. Lloyd's body is found to his home is a 2-minute drive. The crime scene did diagrams and showed that there were 5 shell casings recovered from the scene, 3 of which by the victim's feet. 2 of them were at some distance away, but just above his head. An autopsy was performed. Obviously, the cause being ruled, despite that the manner being ruled a homicide that caused gunshot wounds. But they noted that rigor mortis was consistent with the time that the body had been at the location. The date was fixed, consistent with his position that had been found, and his position was also consistent with having been there. This was not the body that had been dumped there. Based on the autopsy, they determined that there were 2 what they call through-and-through wounds to the chest. One was on the left nipple, the other was almost to the right nipple. Those entered and then traveled through the body, going through numerous organs, and exited his back. As a result of that, crime scene returned to the scene and began to dig the area just immediately under the body. What they found was that those inflicted when this man was down after 2 fatal shots to his body. The projectiles that were recovered were .45 caliber. That was consistent with the 45 caliber casings that were found at the scene, and those 45 caliber shell casings were all matched to the same unknown gun. At 3:27, when he left, the direction out of the scene, the direction he traveled was consistent with the direction that he would go to his own home. In fact, is where he showed up at his own home 2 minutes later. At 3:30 in the morning, when he arrived at his home, the surveillance footage captures him and his two Confederates exiting the vehicle. He spent some time fishing around at the driver's side compartment, as he'd been the driver, and one of the individuals in the back gets out of the car and visibly is seen on the video that he's also carrying a firearm. They go into the house. The defendant was walking through the house with a gun in his hand. That's captured on the video. It's the same black semi-automatic firearm, appears to be a larger caliber, and they all then go down to the basement. Once in the basement, the surveillance is shut off. Later that day, approximately 5:30 p.m., the defendant and his two Confederates appear at the rental agency where they rented the silver Nissan Altima. At that time, they go in to return the car. The defendant offers the attendant a piece of blue bubblicious gum. They return the car, they go outside, they then take a look at the damage to a mirror on the side of the driver's side door. In the video, after the defendant left Boston, that mirror is intact. Sometime between that location and when he arrives in his driveway, that mirror is now broken off. When he's asked about the mirror, he denies any knowledge of what happened to it. Of course, the evidence being he drove that car from Boston all the way back to his house. They traded the rental for a new rental. At that time, they get a price of $300. After taking that car, they go back to his house, and shortly after driving back to the house, the two Confederates get in the car and they leave. The attendant back at the rental car station gets to clean up his car. He finds a shell casing under the driver's seat. And next to the shell casing is a piece of bubblicious blue gum. At the time, the attendant didn't have any knowledge of the case. She picked it up and it was deposited in a dumpster behind the store. Later on, when she indicated to the police what she had done, the police seized the dumpster and a search of that dumpster was made. And at the bottom of it was found a 45 caliber shape of casing, as well as a piece of what appeared to be chewed bubblicious gum. That 45 caliber casing was sent to the ballistics unit. It was compared against the other 45 caliber casings and was matched to those 5 tool marks and stripe marks on the firearm. At the scene, it was extensive work done at the scene. 2 tire impressions were made at that scene. Parallel lines where the tires had essentially made markings in the gravel. Those 2 parallel lines were immediately adjacent to the victim's body. The evidence showed that the victim was killed right outside, right after he got out of the car. The tire tracks show that there were slight depressions toward the front of them, and further analysis showed that those depressions were made when the tire spins, kicking loose gravel to the back. The directionality being as the car then sped up to drive away. Turns out the Nissan Altima, those were consistent now with what would be considered a front-wheel drive vehicle based on the location of the tread marks, and the Nissan Altima being driven by the defendant was in fact a front-wheel drive vehicle. The police further inspected, as a result of the crime scene analysis, they further inspected the Nissan Altima back at the rental agency. Tire impressions were observed appear to be consistent with the treads that were found at the scene. The distance between the tire impressions at the scene were also consistent with the Nissan Altima. The dirt located in the tire treads seemed similar in appearance to the dirt found at the scene. As well, there was also evidence of dirt out inside the wheel well that would be consistent with the tires having spun with dirt in them. search done, because of the nature of the timing between the crime and the 2 minutes to get back to the defendant's home, there was a search done of all the areas in between. While they searched for the murder weapon, they in fact found a different weapon. It was a Jennings .22, approximately a quarter mile from the defendant's home, but on the same route of travel to the defendant's home. The defendant, back a month prior, on May 18, 2013, in Providence, had been involved in an altercation at a bar just outside of bar in Providence, Rhode Island. At the time he was involved in the altercation, there was another individual described as a large black male, hair of a certain type, in braids, I believe. And at that time, that individual was observed taking a gun and putting it under a car. That description matched the individual seen in the video with the defendant on the night of the murder. When this gun, so that gun was then traced, the one in Providence, that was traced to a Florida gun shop. This gun was found on top of leaves as it appeared to have been recently deposited there, and in fact came back to the same gun store in Florida. Police further then sought search warrants and executed them at the home of the defendant. In the course of the search warrant, they found 22 caliber ammunition, although no .22 was recovered. The 22 caliber ammunition was the same type of ammunition that was found in the gun in the area between the crime scene and the defendant's home. They further found a large capacity rifle described as a 7.62 by 39 millimeter FEG Hungarian semi-automatic rifle. The gun had a magazine that was already in it, containing 33 rounds. It was fully loaded. Fingerprints were recovered from that firearm and were matched to the defendant's right palm print. The defendant does not have a license to carry or an FID card, and therefore has no right to possess any firearms. During the course of the search, what was not recovered was the firearm that the defendant had before and after he went out to pick up Mr. Lloyd. The black semi-automatic handgun appears to be of larger caliber, was not found in the home. The gun observed in the second individual's hand was also not found in the home. Later, the police attempted to speak with the defendant's girlfriend. She was willing and cooperative. And during the course of their conversation, the defendant called her and told her to stop talking to the police, and as a result, she didn't. Your Honor, the evidence has established, and the investigation is ongoing, and I suspect will be ongoing for some period of time, but it is established that the defendant alone out of those three individuals had a relationship with the victim. The defendant went to a club on Friday night together with the victim, and apparently at that time is when the victim spoke to people that the defendant was not happy about. Hours before the homicide, the defendant told a third party that he couldn't trust anyone anymore, and he seemed upset. At that time, he was holding a firearm. It was the defendant who made the arrangements to meet with the victim. He then called his friends to come up, and as I indicated by the nature of his text, suggesting there was some urgency that they get up here. When he and the other individual, who was also armed, got into the car and traveled up, he brought up the subject that he was mad about that incident in Boston. He then drove the victim to the remote spot, and then he orchestrated his execution. It was Mr. Lloyd, in some ways a defensive type injury to his right flank. As he tried to turn, he was shot in the back, and as he fell on the ground and the defendant and his confederate stood over him and delivered the two fatal shots, he actually was still alive because one of his arms actually moved up to try and cover one of the first injuries. The defendant then drove home, entered the house with his gun. He disposed of the gun. The next day he changed cars and disconnected his surveillance. He allowed others and assisted others by getting the other vehicle to flee. The evidence will show the defendants had the motive, the means, the opportunity to perpetrate the crime. He orchestrated the crime from the beginning and took steps to conceal and destroy evidence and prevent the police from speaking to what would at least be deemed an important witness. There's strong evidence against him. I'm asking, Your Honor, that the defendant be held without bail pending his trial of this matter. In the Commonwealth, there's no statutory presumption of bail for first-degree murder. The defendant should be held without bail based on the nature of the crime, the strength of the case, the likelihood and the means that the defendant has to flee, and the efforts already that he's engaged in to thwart the investigation of this matter, including the witness, his girlfriend, the evidence, the surveillance, the gun has now disappeared, in providing the mechanism for these other two individuals to flee the jurisdiction. I'm asking he be held without bail, Your Honor. Thank you.
Thank you, Counsel. One moment, please. Sorry, Mr. Bureau.
No, not to be heard, just to pass.
Your Honor, I just want to clarify. Apparently, I misspoke that the text message that was sent at 3:07 was from the sister, strike that, from Mr. Lloyd to his sister.
Not the defendant to the sister.
Yes, I beg your pardon on that, Your Honor.
I figured I'd leave that to counsel.
Okay.
Thank you for the
Thank you.
All right, counsel, do you wish to be heard relative to the defendant's position at this time?
We do, Your Honor. We'd like to be heard on the question of bail.
You sure may.
Thank you, Your Honor. First, let me say that what we see is the treatment of this defendant as any other defendant that would stand before the court, without regard to his celebrity status or the attention that's being paid to this case, the unprecedented lining of the courtroom with police officers and other indicia of a rather hysterical atmosphere. We want this defendant evaluated on the merits as any other defendant would be before this court. First, on the strength of the case, Your Honor, we just heard Mr. McCauley describe the case. It is, at bottom, a circumstantial case. It is not a strong case. If the court separates fact from the inferences and arguments that Mr. McCauley previewed for us that were not based on fact, we'll see that it is circumstantial, not strong. This defendant stands before the court without any record whatsoever. He has never been accused of a violent crime. This defendant is a resident of North Attleboro, Massachusetts, and has been a resident of North Attleboro, Massachusetts. He's a homeowner in North Attleboro, Massachusetts. He lives in a domestic partnership in that home, 122 Ronald C. Meyer Drive, which is so well known to the world now. He lives there with his small baby, 8-month-old baby, and his girlfriend, his fiancée. He deserves to be returned to that home, Your Honor, on appropriate conditions of bail. Let me address the risk of flight issue. There is no risk of flight with this defendant. For the last week, he has been subjected to rumors in the press about imminent issuance of warrants about to be arrested. He has never fled. He has stayed in place. He has obeyed the lawful commands of law enforcement officers when they have entered his property, both with warrants and without warrants. He has cooperated as best he can with his counsel. He has stayed in place. We have notified the district attorney's office when he was going to be on the move, including last week when he came to visit his lawyers in Boston. This defendant it would be practically impossible for this defendant, with the status and the press attention that he has received, to flee with any type of success. The defendant is not at risk of flight, Your Honor. He is willing to submit to appropriate mix of conditions from this court, such as GPS monitoring and appropriate cash bail, so that he could be returned to the community. He would agree to whatever supervision this court would impose, so that he could be treated, as I said, like any other defendant that comes before this court with a clean record, with no history of violence, and in the face of a case that is weak. We would respectfully ask, Your Honor, that the court fashion a mix of conditions of bail that will allow Mr. Hernandez to return to his home, to return to his fiancée, and to return to his small baby while this case plays out.
All right, thank you. Counsel, any other further comment from the co-counsel? No? Okay. And I'll invite the Commonwealth any response in relation to the arguments raised by the defendant. All right, thank you. Folks, after a hearing on the Commonwealth's request for bail, I feel it's appropriate at this time to recognize and to state, for the benefit of anyone having an interest in this case, that there is a presumption under the Massachusetts bail statute that a defendant charged with a crime would be entitled to be released on personal recognizance. In other words, our law requires that we presume that people who are charged with crime would return to the court to attend their criminal cases. That, in effect, is the purpose of the bail statute. However, the presumption of personal cognizance created by the bail statute does not apply to a defendant charged with, in this particular case, a first-degree murder charge. While murder in the first-degree charge is not punishable by death in the Commonwealth, there's a long-standing principle of case law that establishes that the statutory preference for personal cognizance does not apply to this charge. Instead, the law requires that in setting bail in a case involving a first-degree murder charge, that it's a matter of judicial discretion. Now, deciding whether or not to permit the defendant to bail for this charge, the court has to consider the nature of the offense charge, the factual circumstances that have been set out at the time of the arraignment and the bail hearing, and all relevant factors that otherwise under the bail statute. And thank counsel today for their zealous efforts on behalf of their respective clients, both the Commonwealth and Mr. Hernandez. But after the hearing on this matter, the matter set forth in the Commonwealth's case, the court hereby orders that the defendant, Aaron Hernandez, be held without bail pending further criminal proceedings in this matter. I'm going to ask the court magistrate, Mr. Sturdy, to please read the matter into the record of this matter.
Docket 1334, 2057, you are held without bail in this case.
Your Honor, there is one other matter that we'd like to bring to the court's attention.
Folks, we are still in session. Please. Yes, counsel, you may be heard.
Thank you, Your Honor. Your Honor, we would ask the court to enter an order restricting public comment on this case. We believe it is necessary, given the events that occurred over the past week, the numerous reports that have been in the media that have been false, some of those reports attributed to authorities. We have discussed this with Mr. McCauley from the Commonwealth's point of view, and indeed last week I spoke with an assistant district attorney about those reports, and the Commonwealth shared my concern about what was being percolated into the public arena, which has the potential to prejudice Mr. Hernandez and obviously prejudice any jury that would one day hear his case. We've spoken with Mr. McCauley. Our understanding is that the Commonwealth agrees that an order limiting, restricting public comment on this case is appropriate for the court to enter at this time.
And Attorney McCauley, we should be heard from the Commonwealth.
No, Your Honor, that's accurate. We concur.
All right. Now, it sounds easy in principle. In practicality, how would you fashion such an order? Quite frankly, as I understand it, we have the obligation, and certainly we have done that by making this proceeding available to the public. It's required. The court is a public forum. Now, for the court to issue an order restricting public comment, I'm not sure what it is the defendant has in mind or what the district attorney's office has in mind. I'll let you be heard in deciding whether or how, or whether the court has the constitutional authority to put a gag order on planet Earth.
I'd be happy to address that, Your Honor, as a requesting party, if I may.
Sure.
First, obviously the rules of professional conduct apply to the lawyers in this case and address this issue quite clearly. What we are concerned about is other parties that may have access to facts in this case as the grand jury process plays out, as the pretrial process plays out. And what we would ask is just a simple order that would issue from this court to note that anyone involved in this case, we're not seeking to restrict the press or the media or anyone else or raise a constitutional issue. What we are asking for is that an order issue that would restrict individuals involved in this case, both on the defense side and on the prosecution side, which would include law enforcement investigators and the like, from releasing any comment or commenting about this case while it is pending, so as not to prejudice this defendant's rights.
Attorney McCauley?
Your Honor, it's always our intention to only comment, not even comment, to say what's been said on the public record, which is what happens in the courtroom. There be no comment by anybody. I agree with my brother. By any agent of ours, police officer, investigator, assistant DA, the civilians, as you know, I don't think there's a mechanism of keeping them from commenting. But that is not going to be coming from the government's case, and I agree with my brother as to we want to find this case inside the court and not out in the media. Certain things that are put forth are just factually wrong and not coming from law enforcement sources because they're totally inaccurate. So I would agree to any order that the court would fashion that would properly constrain the parties, within the ethical rules, and in addition, because of the nature of this case,
And perhaps, Your Honor, it would help. I would be happy if the order was focused on, for example, the substantive evidence in this case, that is commenting on the evidence in this case, if that would help the court, with its effort at lenity here and trying to draw up a narrow order.
Well, certainly, the court has to be mindful of, in this case, the publicity that's been received, the reports that have attributed certain matters to this court last week, which we know not to be accurate. So it is obviously a concern. The court is empowered to make orders on a pending criminal case concerning the executive branch law enforcement. So certainly agree, and especially if it's agreed to by the district attorney's office, that anyone in connection with the prosecution of this case would be subject to not having public disclosure of the evidence. It's understood both by the defendant and by the Commonwealth that this is a matter that the integrity of the process must remain silent throughout the course of the trial, and the trial is done in court and not out in a public forum. And so we want to try to achieve that if it's consistent with our constitutional mandate as the judiciary. Now, as a practical matter, we have, it's publicly been made aware that we've impounded records recently relative to search warrants, for instance. I don't know if there's a request for us to impound further documents in the clerk's office or in this court. That has gone further. Yeah.
Your Honor, there is, excuse me, Mr. Commonwealth, thank you, sir. We have reached an agreement, Mr. Commonwealth and the defense. There is an affidavit that has been prepared in support of criminal complaints in this matter, and we are both in agreement that for the time being, this affidavit should be sealed. And we on all charges, Your Honor.
On all charges, not just the first charge, but all charges.
Where at times we have to appeal for the public's assistance in locating a particular item or a person. We want to be constrained by today's protection.
That, again, becomes a difficult circumstance. We can think back to circumstances that occurred in Boston recently, and without the public's assistance, that might have gone in a different direction. So it's very clear that the public does have some input to be able to recognize that.
And, Your Honor, we'd be happy to open a dialogue with Mr. McCauley and the Commonwealth if that need were to arise. We've had an excellent dialogue with the Bristol County DA's office, including a dialogue about voluntarily bringing Mr. Hernandez in. If there was ever a need to act in a way that could arguably be consistent with the court's order, we'll discuss it and we would, I'm sure, come to an agreement.
Thank you, gentlemen. I think at this time, I think it's fair to suffice that with regard to the executive branch, the prosecutions of the matter, that the district attorney's office will help assure that the order is complied with, that nobody's to talk about the evidence in this case and it's presented here. Other than that, I don't know that a gag order, so to speak, other people. Anything else from the clerk magistrate?
No, Your Honor, we will be noting an appeal and bail ruling for Superior Court, of course.
We need to do a couple of things first. Mr. Hernandez, you have been arraigned on the charges here today. We do understand that under the Massachusetts law that you could be held in jail without any chance of being bailed out for up to 60 days if you are charged with another offense. It's what we call the so-called bail warning. We recognize, of course, that you're being held without bail at this time. That warning, nonetheless, still suffices in this case. Any other orders that are requested by the Commonwealth at this time? No. Anything else?
No, Your Honor.
Okay, thank you, folks. I appreciate your civil nature of this evening. We do need a date also, counsel.
Next day, we'd like as soon as possible.
Attorney McCauley, probable cause, defendant's entitled to a 30-day date.
We'd love it in 30 days, Your Honor.
30 days would be fine. We can give you July 24th or 26th of this quarter. Knowing full well that it's probably not going to be before it's probable cause hearing this week. We need to schedule that proceeding.
I'm sorry, Your Honor, you say July 24th?
If it's agreed with both sides.
You've been watching the arraignment of former Patriots tight end Aaron Hernandez. We now know that Hernandez is charged with first-degree murder in the connection with the death of Odin Lloyd, the 27-year-old semi-pro football player whose body was found shot As best as we can tell, execution style, about a half-mile from Hernandez's home. We listened to a very detailed report by the district attorney's office outlining the details of this arrest. They cited text messages, shell casings found inside a rental car that Aaron Hernandez had possessed, also surveillance cameras in and around different locations, and also detailing the alleged victim's activities with the defendant that night via text messages. So he has been charged again with 6 different charges, the most notably first-degree murder and possession of a firearm without a license.